We fought the law and the law lost. Actually, we fought the government and the government lost. That's a more accurate way of describing the events that took place recently. We definitely need to talk about everything that just happened, the implications of it all, and what we can expect moving forward. We're on the precipice of a new era, not just for XRP, but for all crypto. For anyone that's been living under a rock for the last few years, allow me to quickly catch you up before we get into the really fun and important stuff. While I'm catching you up, if you appreciate the content, please support the channel by smashing that thumbs up button. And if you are new here, make sure you subscribe so you never miss out on the research that you will always enjoy here, free of charge. Now let's get started. The saga began in March of 2021, when the SEC accused Ripple Labs of illegally issuing securities. This was in reference to the XRP token, Ripple's native cryptocurrency. The agency claimed that XRP was sold as an unregistered security, a move that led to a legal battle and the suspension of the token's trading on major exchanges. In response to these allegations, Ripple Labs demanded internal records from the SEC to get a clear understanding of the basis of its actions. This request, however, has been met with uncertainty, a common challenge seen in previous cases like that of Kick Interactive. Fast forward to March 2023. And we see a surge in the value of XRP by 10%. This was largely due to speculation related to Ripple's ongoing legal battle with the SEC. Rumors began to circulate that Ripple may win the lawsuit, which could potentially impact the token's classification as a security. Adding fuel to the fire was the lawsuit filed by the Commodity Futures Trading Commission, or CFTC, against Binance. This development further spurred speculation around Ripple's case. If Ripple were to win, it was expected that XRP's price would surge, potentially offering clarity on the regulatory treatment of other tokens. Despite the market volatility and the looming lawsuit, the crypto markets were upbeat. Major cryptocurrencies like Bitcoin and Ethereum were trading higher, painting a positive picture for the industry as a whole. In the latest turn of events, as of March 2024, the SEC is seeking a whopping $2 billion in penalties from Ripple Labs. The agency accuses Ripple of unlawfully offering unregistered securities through the sale of XRP. Ripple's chief legal officer criticized the SEC for allegedly misleading statements and expressed the belief that the agency is trying to punish and intimidate Ripple and the wider industry. But it's not all doom and gloom for Ripple. A judge ruled that Ripple's sales of XRP on public exchanges did not violate U.S. trading laws, and the SEC dropped claims against Ripple's CEO and co-founder back in 2021. The courtroom is a stage where every statement counts. Let's explore the key highlights from the hearing. The hearing was a significant chapter in this ongoing saga between the SEC and Ripple. It was a highly charged event, with every word weighed and every argument scrutinized. The statements made by the judge were particularly noteworthy, as they provided valuable insight into the court's perspective on this complex case. The judge's stand was nuanced, reflecting the complexity of the case. She acknowledged the pioneering nature of cryptocurrencies and their potential to reshape the financial landscape. However, she also highlighted the importance of regulations to maintain market integrity and protect investors. Her words underscored the delicate balance that needs to be struck between innovation and regulation in the rapidly evolving world of digital assets. As for Ripple's latest response to the SEC's penalty demand, the company made a strong case. Ripple argued that the proposed $2 billion penalty was excessive and disproportionate. Instead, the company proposed a $10 million fine, a figure that they believe reflects the actual harm caused. Ripple's argument was not just about numbers, but also about principles. They argued that a $2 billion penalty would stifle innovation and create a chilling effect on the broader crypto industry. The judge's actions during the hearing also spoke volumes. She showed a keen understanding of the issues at stake and a willingness to question the SEC's arguments. This open-minded approach could potentially pave the way for a more nuanced understanding of digital assets within the legal system. Defense attorney James Phelan shared the latest from the ongoing SEC versus Ripple, saying, Ripple has filed a motion to strike new expert materials the SEC submitted in support of its motion for remedies and entry of final judgment. According to the court filing, Ripple requested that the court ignore new SEC submissions supporting its opening brief and request for final judgment. Ripple lawyers argued, the parties engaged in more than 3 months of remedies discovery. During that time, Ripple served a supplemental expert report on disgorgement, and the SEC deposed Ripple's disgorgement expert. The SEC waited until the filing of its remedies motion to submit the Fox declaration setting forth its remedies theories and calculations. Ripple went on to say, "The Fox declaration contains accounting analysis and substantive conclusions about remedies that the Federal Rule of Civil Procedure and this court's orders required the SEC to disclose during discovery. The SEC's untimely submission is precisely the type of sandbagging that Rule 37(c)(1) is designed to prevent." The Fox declaration relates to SEC expert witness Andrea Fox, a declaration form, and 2 accompanying exhibits. Andrea Fox is an accountant in the SEC Enforcement Division. Ripple argued that Andrea Fox gave expert testimony regarding Ripple's accounts and appropriate penalties for XRP sales to institutional investors. The SEC should have disclosed the identity of the expert witness and her testimony during discovery. Ripple also highlighted that the SEC stated Fox was a summary witness, not an expert witness. Summary witnesses do not offer new information. The SEC opposed the motion. Moreover, the parties agreed for Ripple to propose the SEC have 5 business days to file an opposition brief to the Ripple motion. The proposal would give Ripple 3 business days to submit a reply brief. The latest court filing and SEC legal maneuvers could draw more scrutiny than usual. In addition to this, on Monday, news hit the wires of 2 SEC lawyers stepping down. The lawyers were involved in the SEC versus Debtbox case. In March, Judge Robert J. Shelby denied an SEC motion to dismiss the charges against Debtbox. In the court ruling, Judge Shelby highlighted the SEC's abuse of the judicial process, concluding the SEC engaged in bad faith conduct. The SEC filed the motion to dismiss in response to a court order in December, where Judge Shelby ordered the SEC to present arguments against the court, sanctioning the SEC for making false and misleading representations in court. The resignations coincided with the Ripple motion that called the SEC's attempts to sandbag. Investors await a court response to the Ripple motion. A court ruling in the SEC versus Ripple case could impact the SEC plans to appeal against the programmatic sales of XRP ruling. The SEC could face more intense scrutiny if Judge Sarah Netburn raises concerns about the SEC's inclusion of expert testimony after discovery. Amidst the legal turmoil, Ripple's partnerships stand as a testament to its potential. Who are these partners and what do they mean for Ripple? To truly grasp Ripple's potential, it's essential to understand the partnerships it has fostered over the years. As a digital payment protocol, Ripple has managed to attract several banks and financial institutions to its network. This network, known as RippleNet, allows these institutions to transact swiftly, securely, and cost-effectively across borders. One of Ripple's most significant partnerships is with Santander, one of the largest banks in Europe. Santander uses Ripple's X-Current technology to facilitate international money transfers. The bank has even launched a mobile app powered by Ripple for cross-border foreign exchange. In Asia, Ripple has partnered with SBI Holdings, a financial services company based in Japan. Together, they have launched SBI Ripple Asia, a venture aimed at exploring the use of Ripple's payment technology in Asian markets. American Express and Standard Chartered are other noteworthy names that have adopted Ripple's technology. These partnerships not only validate Ripple's technology, but also grant it a significant competitive advantage. Ripple's technology has managed to pique the interest of more than just banks. Payment service providers, such as MoneyGram, have also been drawn to its potential. MoneyGram uses Ripple's X-Rapid service for settling cross-border payments. In the future, Ripple's list of partners is likely to grow. The company has been proactive in forging partnerships with institutions that can benefit from its blockchain-based solutions. But what does this mean for Ripple, especially in light of the ongoing SEC case? Well, these partnerships could serve as a strong defense. They prove that Ripple's technology has practical applications and is valued by established institutions. This could help counter the SEC's claims that XRP is an unregistered security. Moreover, these partnerships could give Ripple an edge over its competitors in the blockchain space. While the likes of Bitcoin and Ethereum have gained popularity as investments, Ripple is carving out a niche for itself as a practical, problem-solving technology in the financial sector. In conclusion, while Ripple's legal woes are far from over, its partnerships with banks and financial institutions might be its saving grace. Not only do they lend credibility to Ripple's technology, but they also provide a glimpse into a future where Ripple's digital payment protocol becomes a mainstay in global finance. These partnerships could be Ripple's stepping stones to a bright future post the SEC case. Every cloud has a silver lining. Could the SEC case be a catalyst for a potential upside in XRP's price? Despite the legal challenges, It has maintained a valuation of over $35 billion, underlining its resilience. And now, with the possibility of Ripple winning the lawsuit, we could be looking at a significant price surge. A favorable verdict for Ripple could fundamentally alter the perception of XRP. No longer viewed as a potentially illegal security, but as a legitimate digital token, XRP's appeal could skyrocket, pulling its price along with it. But that's not all. Ripple's partnerships with banks and financial institutions could also contribute to a potential price surge. With the legal hurdles out of the way, Ripple could fully leverage these partnerships, enhancing its use case and creating a higher demand for XRP. The CC lawsuit is a chapter in Ripple's journey, but what does the next chapter hold for XRP and Ripple? As we've seen, Ripple has weathered the storm of this legal battle, maintaining strong partnerships with banks and financial institutions, and keeping the sixth largest cryptocurrency by market capitalization afloat. Should Ripple win the lawsuit, we could see a surge in XRP's price, not to mention the ripple effect it could have on the classification of other digital tokens. This outcome could potentially usher in a new era of clarity and acceptance for cryptocurrencies. Moreover, Ripple's use case stands out among its competitors. Its ability to provide fast, low-cost international money transfers is already being recognized by several financial institutions. With the conclusion of the lawsuit, we could see an expansion of these partnerships, solidifying Ripple's position in the crypto market. But let's not forget the resilience of the crypto community. Despite the ongoing legal battle, the faith in XRP's potential remains unshaken. This is a testament to the strength of the technology behind Ripple and the vision of its creators. As we stand at the crossroads, the future of XRP and Ripple looks promising, shaping a new era in the crypto world.